any faces anyway, Ankit, because perfect. So, but the option is there in case you want to move.
Right, I hope this is visible.
Yes.
Perfect. Well, let me begin by thanking the organizers for going ahead and organizing such a timely event. It was also interesting to hear thoughts from the previous speakers about publishing, and I can vouch for that. That the journals and also articles play such an instrumental role, so much so that you've actually had it enshrined in the International Court of Justice's statute. And that's something which this presentation deals with as well. It deals with the court and also one of the most recent cases in its docket. You see on the first slide, this conversation begins, or at least a part of this conversation really begins on the 27th day of June in 2023, when the political landscape was stirred by Iran when it launched these proceedings against Canada in the court. And this claim really centers around terrorism exceptions when looking at Canada's State Immunity Act, which defies customary law according to the Iranian counterparts. While Canada is directly in crosshairs of this lawsuit, a closer examination suggests that the United States, not Canada, might be the ultimate target of Iran's maneuver. The principle of state immunity, which I am sure is familiar to all the members of this audience, states that states should be protected from jurisdiction of foreign national courts. However, with the growing concern of transnational terrorism issues, these countries such as the United States, Canada, even the United Kingdom have adapted and integrated exceptions to this principle, especially with regards to state-sponsored acts of terrorism. But going back to the question as to why Iran chose Canada in the ICJ, especially when the United States courts operating under the Foreign Immunity States Act, short as FCIA, that have consistently ruled against Iran, attributing billions in damages. The answer perhaps lies in a strategic subtlety. Iran's relations with the US are charged, strained by decades of political tension and mistrust. Direct legal confrontation with the United States in an international arena could exacerbate these tensions further, making a diplomatic resolution of these issues completely impossible. Canada, on the other hand, despite being a close ally of the United States, maintains a much more neutral stance when it comes to direct relations with Iran. By challenging Canada's State Immunity Act, Iran might be aiming to achieve a two-pronged objective. First being to establish that terrorism exceptions in national laws are inconsistent with international norms. Iran could potentially weaken the foundation on which the US's court's judgment rests on. If the ICJ were to rule in Iran's favor, it would cast a longer shadow on the doubt over the legality of provisions in the United States' FCIA. Secondly, a favorable verdict against Canada could also serve as a precedent in making challenges against the US court's order to enforce these rulings based on contested terrorism exceptions. So, therefore, in essence, Iran's lawsuit against Canada in the ICJ is actually a manifestation of an intricate interplay between international law and geopolitics. The immediate legal battle against Iran's legislation is actually an overarching strategy of the broader challenge against the US's approach to state immunity exceptions. It therefore becomes clear that this case is less about Canada and much more about the United States' legal onslaught against the Iranians. Through this lawsuit, Iran is not only challenging a specific Canadian legislation, but also indirectly the United States' approach towards state terrorism and state immunity. Whether this proves to be a masterstroke in Iran's favor or backfires will be keenly watched by the scholars but also practitioners practicing in domestic courts dealing with issues of international law. In respect of background, I wouldn't spend too much time because this audience does understand the intricacies of state immunity, and I shall only refer in passing to the Lotus Principle, which emphasizes state equality and also ensuring that the interaction between international affairs and the fair and legal judicial interventions from another state are also inherent in the Westphalian system in the United Nations Charter. The Canadian Act and also the US Act are two prominent examples of the shift in the traditional blanket of state immunity. Both these statutes serve to the core of state immunity, but make exceptions, allowing for certain legal actions against foreign states under certain circumstances. Those being under Section 611, which creates an exception to state immunity when a foreign state is listed as a supporter of terrorism under the Justice for Victims of Terrorism Act. The United States, similarly, in 1996, in amending its act, especially Section 28 of A7, followed claims against foreign states designated as state-sponsored terrorism for personal injury or death caused by certain acts of terrorism. While these exceptions are rooted in the noble objective of holding states accountable for egregious acts, they are not without contention. It can therefore be argued that these principles erode the principles of sovereignty and open the doors for potentially legally and also politically motivated actions. Therefore, the reflections in these courts reminds one of the case between Germany and Italy. In that, the court reaffirmed the general principle of state immunity, but therefore cautioning expansive exceptions. In summary, therefore, state immunity is grounded in sovereign equality and non-intervention, but has been the cornerstone of international relations. Yet realities of transnational terrorism have compelled states like the United States, the United Kingdom, but also Canada, to re-evaluate the blanket and look under it, and perhaps in some sense reduce the size of their blanket. The core issues within the case are also permeated in other international legal instruments of not just the state but also of the United Nations and also the 1972 Convention on State Immunity of the European Convention, but also to the 2004 United Nations Convention on Jurisdictional Immunities of State and Their Property. Not law, but still carrying a normative value. But with respect to the United States, the terrorism exception is starkly embodied in the foreign FCIA, which was initially enacted in 1976, underwent a critical amendment, as I was discussed earlier, through the Anti-Terrorism and Effective Death Penalty Act of 1996, and then was codified as I shared earlier. But it also pays specific emphasis on state-sponsored acts of terrorism, provided that certain conditions are met, including that these provisions compensate towards U.S. nationals for injury or death caused by these acts of terrorism. A glowing example in this regard is the Peterson versus Islamic Republic of Iran case in the U.S. courts, wherein the victim of a 1983 bombing in Beirut successfully obtained a judgment against Iran, holding it responsible for the acts committed by Hezbollah, a group of purportedly backed by Iran. Such instances provide legal recourse for victims, but also highlight the expansion of national courts' jurisdiction over traditionally immune sovereign states in matters related to terrorism. As I had also mentioned the case of Germany versus Italy, that needs to be further discussed, because in that case, Germany's immunity against the Italian claims related to World War II atrocities emphasize the exceptions to state immunity, especially to those at odds with international consensus, and can endanger the international order. The court's decision underscores the idea that state immunity principles shouldn't be easily overridden, even when confronted with serious international crimes. Critics of the terrorism exception argue that it threatens the principles of reciprocity inherent in state immunity. But by allowing national courts to exercise jurisdiction over another state, the accepting state opens itself up for sort of similar treatment. Furthermore, the exception risks transforming legal disputes into political confrontations, undermining the objective of the nature of judicial proceedings and possibly exacerbating the international tensions. For example, as you have seen in the case of Iran under the FCIA, are viewed by some less about justice of the victims to an exertion of political pressure. Therefore, in short, what one can say is that the US offers the victims a semblance of justice and a tool against state-sponsored terrorism, but they also challenge the most fundamental principles of state immunity. Whether these exceptions represent a national evolution in the face of global challenges or a derivation from legal existing norms remains to be seen further. But returning to the case in hand, the Iranian strategy is also something that requires further discussion. While you have the example of the Peterson versus Islamic Republic of Iran, where the courts held Iran liable for the damages and also the actions of the 1983 bombing of US Marine barracks in Beirut, resulting in a judgment of over $2 billion against Iran, there is also another example, which is Heiser versus Islamic Republic of Iran, which linked the bombings of 1996 of the Khobar Tower bombing in Saudi Arabia. These judgments, these two and others which are not discussed in this paper, have a culminative effect of holding Iran liable for billions of dollars in damages. This has significant financial burdens and an affront to their sovereignty and a political strategy that the US uses to pressurize Iran and also isolate it on the international stage. This is also another layer of tension already fraught between the US-Iran relations, characterized by diplomatic breakdowns, economic sanctions, and military confrontations. Canada, on the other hand, much like the US's FCIA, incorporates terrorism exceptions which allows it for stripping immunity in cases involving support for terrorism. The SIA of this is the Canadian version, has been used to hold Iran accountable in Canadian courts. Similarly, the actions of the US courts and the FCIA have followed suit. By challenging the legality of this, Iran is attempting to create a precedent at the highest international level of adjudication. It does so that it can present a strong legal basis against such provisions of other jurisdictions, therefore challenging the American claim. It also goes against and follows on the case of the Nicaragua versus the United States case, which is the emphasis that is used on customary international law principles, especially those in regard of non-use of force, non-intervention, must adhere to by all states. A ruling against the SIA could reaffirm these principles and also the legality of terrorism exceptions. It could also, by focusing on Canada, Iran might be sidestepping the confrontation with the US at the ICJ. Canada, despite its close alliance with the US, has a distinct legal personality, which you can see coming at the forefront in the tensions that it has with India. The wider implications of this court could also have a three-pronged effect. First being the re-establishment of a traditional norm, as you had seen in the Germany versus the Italy case, wherein Greece also intervened, and the court did uphold the immunity against claims of human rights violations. This could send a message of crafting a national legislation which might infringe upon those established principles, potentially leading back to a rollback of similar legislations in other countries. The second could be validating its exceptions. Conversely, the ICJ rules against Iran. It could set a precedent that strengthens the legal validity of exceptions to state immunity, particularly in the context of terrorism. There is also an interconnected relationship between geopolitics and the law. The influence of this dynamics of the decision could also remind one of the advisory opinion rendered in 1996 on the legality of nuclear weapons. It serves as a testament to this matter because of the straightforwardness of the question, yet the burgeoning discourse within and the disgruntled opinions and the political tensions of nuclear disarmament. The ICJ's influencing role as an international leader or a political tool could also have significant effects on the politics, but also the norms that I have emphasized on this presentation. Perhaps a few concluding thoughts that one would like to offer in this respect is that, well, while the court is dealing with issues and is busier than ever before, this matter requires a further study, because at the heart of this dispute of state immunity is one of the most important cornerstone principles enshrined in the UN Charter, but also in the United Nations United Nations Charter, but also the Vienna Convention on Diplomatic Relations. State immunity is that principle where sovereignty and sovereign capacity are enshrined and encoded. There are exceptions to this immunity on jurisdiction in foreign courts, but Canadian legislation, just like the US, contains provisions which can carve out exceptions. But these exceptions have now further created and snowballed into the erosion of state immunity principles, the political dynamism, and also the ramifications of global politics, but also the precedent for future states, which will undoubtedly influence the legislation, the health of the legislation, and also the future trajectory of such legislation. To perhaps conclude, one can say that while on the surface, Iranian's lawsuit against Canada, ICJ, pertains to a specific issue in the SIA, the underlying issues and potential consequences are far-reaching. The dance of diplomacy, law, and politics on the international stage is intricate, and this lawsuit is set to play a defining role in shaping this choreography. With those words, I thank the organizers once again, and also everyone else for their patient listening. Thank you.